and welcome to Strategy classes. In this video, we would be discussing the adultery judgment pronounced by the Supreme Court on September 2018 in detail. The five-judge constitutional bench of the Supreme Court, headed by the then Chief Justice of India, Justice Deepak Misra, decriminalized adultery. So, in this video, we would look at all the aspects of the judgment, as well as we would understand what is criminal offence, what is civil offence, and what is the definition of adultery as per the Constitution or the IPC. Adultery has been defined according to section 497 of the IPC, that is the Indian Penal Code. The section 497 of Indian Penal Code provides adultery as a criminal offence, but if found guilty of adultery, the wife or the female would not be prosecuted. The male would only be treated as under the criminal offence. So let's understand it. Suppose consider there exists an husband and a wife. Now an outsider, let this outsider be a man. This outsider establishes physical relationship with the wife without the consent of her husband. Then this act of physical relationship would be considered as adultery. If this outsider male would have been established physical relationship with the wife with prior consent of her husband, then it would not be coming under adultery. It would not be considered as an adulterous act. If the husband had the consent, then it would not be considered as adulterous act. The reason provided behind it is wife is the property of husband. The reason behind it provided was wife is the property of husband, hence consent of husband is a prior requirement in order to establish physical relationship with the wife. But what if husband establishes extramarital relationship with an outsider female? This outsider female might be a widow, might be a divorcee, or might be an unmarried female. Then no charges of adultery would be acting under the female or the husband, because husband is not the property of wife. Wife is the property of husband, but husband is not the property of wife as per the then existing section 497 of IPC. Now what Supreme Court, the question in front of Supreme Court was, is section 497 constitutional or is it unconstitutional? So before going into the debate of constitutionality of section 497 of IPC, let's take a look how this British era law started forming. When the British rule was present, first law commission was established under the precedence of first law commission in 1837, presided by Lord Macaulay. Lord Macaulay presided over the first law commission 1837. This marked adultery as a civil offence. So what is the civil offence? Two types of offences are there. One is criminal offence and other is civil offence. If there exists a dispute between two individuals, then it is known as civil offence. But if an act threatens the sovereignty or the society of the state, then it would come under criminal offence. What could be the examples of criminal offence? Terrorism. Terrorism is a threat to the state, to the society. It could be a criminal offence. Murder is trying to distort the balance of the society. It would be coming under criminal offence. rape, dacoity, these all would be considered as criminal offences. Adultery in the first Law Commission of 1837 presided over by Lord Macaulay considered as a civil offence, but the second Law Commission came into picture now. The second Law Commission of 1860 presided over by John Romilly, Sir John Romilly, considered adultery as a criminal offence. And this Law Commission, the second Law Commission, kept the woman out of the ambit of the wrath of the law. That is, women would not be considered as an abettor and would be free from prosecution. The second Law Commission, it prescribed under various grounds because there are various discriminations existing against the women, like child marriage, huge age gap difference between the spouses. Considering those things in mind, the second Law Commission exempted women from being persecuted. Also, at that time, there was a common notion among the society that man is the initiator and woman is the victim. So, keeping all this in mind, the second Law Commission, presided by John Romilly, criminalized adultery and the women were exempted from being prosecuted. Now, after India got independence, we witnessed various Supreme Court observations regarding adultery. We would look to the primary two of the judgments of Supreme Court regarding adultery. The Supreme Court pronounced Yusuf Abdul Aziz versus State of Bombay. In this judgment, the court held that Article 15 Clause 3 provides for any law doing special law for special empowerment of women. So it held that women not being a abettor is a law that is empowering women. Hence, adultery cannot be decriminalized. Now the next case that came was Revati versus Union of India. Revati versus Union of India 1988. In this case, the Supreme Court invented the doctrine of reverse discrimination. The Supreme Court invented in Kesavananda Bharati case, the Supreme Court had invented the doctrine of basic structures. Similarly, in Revati versus Union of India, the Supreme Court invented the doctrine of reverse discrimination. So what is doctrine of reverse discrimination is? In India, considering the society of India, it is always considered that women have been discriminated from their male counterparts. Hence, if in somewhere reverse discrimination is happening, then it was considered legal in Revati versus Union of India case. Hence, adultery continued to be criminalized offence for the male perpetrators. So, let's take a look at the personal laws of the majority of the communities, that is Hindu and Muslims. In fact, if you know, under Hindus, in the personal laws, Sikhs, Jains, Buddhists, all are coming on. So, Hindu personal law has been mostly derived from Manusmriti. And Manusmriti provides a wider definition or a broad definition of adultery. By broad definition, I mean if you touch the ornaments or the clothing of a married woman, you will be charged under adultery. If you are roaming around a married woman, you will be charged under adultery. If a person sits in the bed of a married woman, it would be considered under charges of adultery. Whereas, on the other hand, the Muslim law, the Muslim personal law, provides a narrow aspect of adultery. Why narrow? Suppose two individuals, one male and one female is there. I am labeling charges that they both are in an adulterous relationship. Suppose the both of them are married. Now I am labeling charges against them that they both are in an adulterous relationship. To prove the charges, I have to bring 4 witnesses who had witnessed the sexual act performed by both the individuals, which is a very difficult task. And also, both the male as well as the female must be in a separate married relationship. Then only under Muslim personal law that act would be considered as adulterous act. Hence, it provides a narrow scope, but in Hindu personal law, it provides a broad scope. Now, coming to the Supreme Court judgment, the 2018 verdict, we have to look after what Supreme Court provided in its under its 2018 verdict. In 2018, the 5-judge Supreme Court Constitutional Bench, headed by the then Chief Justice of India Deepak Misra, decriminalized adultery. The then Chief Justice of India, Justice Deepak Misra, held that any constitution cannot indignify the status of a woman, cannot indignify the status of woman. He also held the observation that husband is not a master nor a sovereign over his wife. Another judge of the Constitutional Bench, Justice Nariman, held another view that no doubt adultery goes against Article 14, that is right to equality, but it also goes against Article 15, that is discrimination on the basis of sex. You cannot discriminate between two individuals just because of difference in gender. He also observed that the common notion of man being a perpetrator and woman being a victim is changing with the changing world. Further, Justice D.Y. Chandrachud, another judge in the Constitutional Bench, held a statement, observed and said that marriage is not a binding force upon the sexual freedom of any woman. Justice Indu Malhotra, the only female judge in the Constitutional Bench, said that no, adultery can be considered as something which is moral wrong. It might be wrong morally, but it cannot be criminalized. It can be under civil offense because it can be morally wrong, so we can put it under civil offense, but we cannot criminalize adultery. Hence, the 5-judge Constitutional Bench pronounced a 5-0 verdict and decriminalized adultery. So, if you like this video, if you like our initiative, you could press the like button, subscribe to our channel for more updates, and do comment regarding anything about the video. Thank you.